Good afternoon and welcome to the In Defense of Christians discussion panel on human rights lawfare. My name is Richard Gazelle, Executive Director at IDC, and I'll be your moderator today. When considering human rights violations and crimes of terrorism, lawfare is a unique and effective means to enforce accountability, make victims, survivors, and families whole, and influence the behavior of state and non-state actors. Lawfare, of course, is a general term which takes on many forms and applications, from civil litigation in U.S. federal court to targeted sanctions to leveraging international enforcement bodies. During the session, we hope to provide a focused deep dive into the relevant issues surrounding lawfare to hold human rights violators accountable and secure justice for victims and survivors. Panelists will each deliver opening remarks followed by a question and answer session, questions coming from the moderator as well as you, our audience today. So it's my honor to introduce our first expert panelists. Professor Ord Kittry is a senior fellow at the Foundation for the Defense of Democracies and professor of law at Arizona State University here at their Washington, D.C. campus. Professor Kittry is also a fellow in the Office of the Legal Advisor to NATO's Supreme Allied Commander in Europe. Professor Kittry is an expert on the intersection of U.S. foreign policy and international law, particularly as it relates to the Middle East, and is the author of the book Lawfare, Law as a Weapon of War. Professor Kittry, welcome.
Thank you very much. Hello, everybody. I'm delighted to be here alongside two old friends, Eric and Steve, and two new ones, Sean and Richard. I'll focus today on lawfare opportunities and challenges for religious freedom advocates vis-a-vis international governmental organizations, such as the United Nations. I'll do so by way of a case study of the UN Human Rights Council. It's a good starting point because it's both important and because, as I will discuss in detail in a few minutes, the UN Human Rights Council currently demonstrably undermines religious freedom. Currently demonstrably undermines religious freedom. But first, some overall comments about the state of international organization lawfare today. Those in the religious freedom community with an interest in lawfare should take note of how Ukraine has, particularly in recent months, made masterful use of international organizations in a lawfare campaign against Russia. In doing so, Ukraine has undertaken an exceptionally sophisticated and systematic approach to lawfare. Ukraine and its allies have clearly gone through a kind of checklist of the major relevant international institutions and analyzed for each one how to effectively use law as a weapon. Then they've gone ahead and done it. Ukraine has, in my view, thereby joined two countries, Israel and China, and one alliance, NATO, the North Atlantic Treaty Organization, in running the world's most sophisticated and systematic lawfare operations. It seems to me that the religious freedom community ought to strongly consider doing something similar, undertaking a similarly systematic and sophisticated approach to lawfare. The religious freedom community obviously doesn't have the resources of nation states or NATO, but starting to take a systematic approach to lawfare is not necessarily expensive. You really just need to commission a small team to systematically survey the landscape for offensive opportunities and defensive challenges, and then keep the survey updated. Once you've undertaken the survey and spotted the opportunities and challenges, you can decide which opportunities and challenges to try to address. You'll, of course, need to triage in a manner consistent with the magnitude of your resources. But, of course, once you spot a particular interesting opportunity, it may be possible to generate resources specifically to address it, possibly even new resources which don't cannibalize other projects. Perhaps there's a donor specifically interested in your lawfare religious freedom project. Or, and this may be more likely, you can interest a skilled attorney or team of attorneys in undertaking the project on a pro bono basis. This is what Ukraine has done. That's one particular and perhaps relatively unique benefit of lawfare projects. if the resources generated to address them are pro bono lawyer hours, they're likely not going to cannibalize your dollar fundraising for other projects. Right? Now, I'm not an expert in religious freedom issues, but I'm sympathetic to religious freedom issues and an expert on lawfare. So I'm going to use the rest of my time to suggest what appears to me at first glance to be a particular international organization, offensive opportunity, and defensive challenge on which religious freedom advocates may wish to focus. That's the UN Human Rights Council. The UN Human Rights Council is an intergovernmental body within the UN system which is theoretically responsible for strengthening the promotion and protection of human rights around the globe and for addressing situations of human rights violations and making recommendations to end them. Who's on the council? The council is made up of 47 UN member states, which are elected by the General Assembly. This year, the 47 members of the council include the US and human rights respecting allies, including Czech Republic, Finland, France, Germany, Japan, the Netherlands, and the United Kingdom. These 47 members also, unfortunately, include various countries with very poor human rights records, including on religious freedom. This year, the members include the following countries rated not free by Freedom House: Cameroon, China, Cuba, Eritrea, Gabon, Kazakhstan, Libya, Qatar, Somalia, Sudan, Uzbekistan, and Venezuela. You may recognize some of them as, on human rights generally, but religious freedom in particular, among the world's worst. Yet there they are on the UN Human Rights Council. Why are they there? Why do they want to be there? Well, an empirical study published in 2018 by a reputable expert named Peter Henn, a professor at the University of Vermont, poses the question: does the UN Human Rights Council help or hurt religious repression? The study's findings were remarkable, but sadly not surprising to those of us who have studied the council as a whole. The study found that the Human Rights Council has, quote, a negative impact on religious freedom. Specifically, it found that increased state activity at the Human Rights Council, states that were members, states that were particularly active at the Human Rights Council, that corresponds to an increase in a state's repression of religious groups. The study concluded that the Human Rights Council serves not to improve human rights through transparency, but rather to give repressive regimes cover to undermine religious freedom. As Professor Henn put it, while it's not surprising that repressive states try to use the HRC, the Human Rights Council, to deflect criticism of their records, it's significant that this deflection seems to work. This, my friends, is a broken institution. I think that this remarkable situation, though, is an opportunity, right? It means that for religious freedom advocates, the Human Rights Council provides both an opportunity for advancing proactive objectives by urging the council to affirmatively advance religious freedom through its reports and resolutions, but also an opportunity for advancing what one might call defensive objectives by finding ways to ensure that the council stops contributing to an actual worsening of religious freedom in member states. There's a particular opportunity this year because the US in January rejoined the Human Rights Council. The Trump administration withdrawn from the Human Rights Council while spotlighting its problems. In announcing the US's return to the council, Secretary of State Blinken said as follows, and I'm going to read the quote from him because I'm trying to hold him to that commitment, and I recommend that all of you try to hold him to that commitment. He says, look, he says, we recognize that the Human Rights Council is a flawed body in need of reform to its agenda, membership, and focus, including, he says, its disproportionate focus on Israel. However, says Blinken, our withdrawal in June 2018 did nothing to encourage meaningful change, but instead created a vacuum of US leadership, which countries with authoritarian agendas have used to their advantage. Yes, they have, is my comment. Blinken goes on, it's our view that the best way to improve the council is to engage with it and its members in a principled fashion. We strongly believe that when the US engages constructively with the council in concert with our allies and friends, positive change is within reach. So he is trying to make a difference. Is he succeeding? To some extent, on some issues, I would say. And certainly the Biden administration, in my dealings with them, has been pretty open, willing to listen to suggestions about how to improve things. Since the U.S. returned to the Human Rights Council in January, the U.S. has made some progress. For example, the U.S. managed to get Russia expelled from the UN Human Rights Council for its violations in Ukraine. The U.S. also appears to have managed to cut the budget of a UN Commission of Inquiry into Israel and to get the Commission to hold back a bit in its criticisms. And again, when you have the Biden administration going in and saying, look, we understand this is flawed, but we're going to make a difference, you can write op-eds, as I have, saying, well, here's an issue on which you should be making a difference. We're watching to see if you do it. And like I said, they get a mixed grade, probably a B at this point for me, in terms of, like, they're trying, could they be more effective? Yes, they could. They're trying particularly on issues which have been brought to their attention. To my knowledge, religious freedom is not an issue which has been brought to their attention as this is what you need to do to improve the UN Human Rights Council on religious freedom. So what does the UN Human Rights Council do? I'll note it's not a legislative body. It doesn't have the authority to convict and punish individuals, but it has a considerable and growing legal impact. One of its major functions is spotlighting human rights violations around the world and urging change. It creates investigatory commissions, promulgates resolutions. In practice, the Council plays a major role in driving the world's human rights agenda and interpreting human rights law. In my own research and advocacy work, I've seen how it's possible for outsiders to influence the work of the Council in various ways. Points of leverage, specific points of leverage include Council funding, personnel, and policy/legal substance. A religious freedom advocacy agenda could address all three. In my closing couple minutes here, I'll give you some examples, some illustrative, specific success stories from the last year to address how this can be done. Okay, funding. Last year, the UN Human Rights Council voted to create a new commission of inquiry to investigate Israel. Now, some of you may have different views on Israel. The point is not to talk about that. The point is to give examples of how the UN Human Rights Council can be influenced. As I've written in a series of op-eds, the mandate for the Israel Commission was remarkably broad, quite biased in my view. The UN appointed to the three commissioner positions three people with records that I considered to be extremely anti-Israel. The UN then proposed a large budget and staff for the commission, Those budget and staff numbers, I discovered, were subject to a revision by a particular very obscure UN internal body. We drew the Biden administration's attention to this and encouraged them to act. They did. They voted to zero out the commission staff and budget. They didn't win on that one, but they did manage to pass a 25% cut in the commission staff and budget. This cut both hindered the commission's operations and put the commissioners on notice that they were under scrutiny and needed to tread carefully if they didn't want their next budget to be zero. Yesterday, as it happens, we had another victory vis-a-vis funding for the commission. The House Appropriations Committee unanimously passed an amendment prohibiting any U.S. funds from being used to support that particular commission. I was pleased because I had written an op-ed just last week calling on Congress to do exactly that. Since the U.S. contributes 22% of funds for that part of the UN budget, this legislation puts pressure on the UN to scale back or halt the commission. Now, let's turn to personnel. As I had mentioned before, the UN appointed to the three commissioner positions three people with records that are extreme. And you may find the same with regard to your issues. You're like, oh my God, these people are the three commissioners for investigating China's persecution of the Uyghurs or whatever it is. How can they have chosen these people? Well, if the UN Human Rights Council appoints a commissioner who's exceptionally hostile to your agenda, you could do some deep dive research about the commissioner. A few years ago, someone discovered, and this is public, that the chair of a prior UN Human Rights Council Commission of Inquiry into Israel had served as a paid consultant to the PLO. Somebody found this out. And when that became public, the commissioner was forced to resign. And his replacement had a far less problematic record, right? So this is another concrete, specific thing you can do. Then we turn finally to policy, legal substance. Obviously, the most intuitive way for the religious freedom community to advance its agenda an international governmental organization is through policy and legal substance. This can include, and I'll provide 3 examples, and you can do these either directly or working through the US or another friendly government. First of all, you can bring religious freedom violations or other issues to the organization's attention and suggest what the organization should do about them. Number 2, you should monitor religious freedom violations or other issues the organization is already addressing, and you can weigh in with public advocacy and formal submissions. Human Rights Council commissions of inquiry, including the one on Israel, typically make formal requests for submissions by non-governmental organizations and efforts. And I've seen how the commissioners do reference. They feel that they get put on the defensive by submissions that are maybe counter to their views, and they respond to them. And finally, it's important to watch legal interpretations the organization is making or appears poised to make. I noticed that the Israel Commission of Inquiry, which the UN Human Rights Council created last year, implicitly created the groundwork for falsely accusing Israel of committing the crime of apartheid. Now, Israel is not perfect. However, they are not committing apartheid, in my view. It's just apartheid is a very particular definition. So how did they lay the groundwork? Well, the commission's mandate included language redefining the international crime of apartheid in a way which would facilitate them accusing Israel of violating. And you may see with regard to religious freedom issues, you're like, gee, that's not the traditional definition of that. I wonder if they've redefined thus and such in order to get China off the hook vis-a-vis the Uyghurs. Watch for that kind of thing, right? They do that. And so what do? Well, I noticed this redefinition. I sounded the alarm and others joined in. And it's my understanding that it was made clear to the commissioners that if they proceeded with their scheme to accuse Israel of apartheid, last year's 25% budget cut would have been expanded perhaps even to 100%. So they issued their first report a few weeks ago, and lo and behold, there was no apartheid accusation. I hope these examples have provided a useful flavor of how our religious freedom lawfare agenda focused on international organizations could, certainly in the case of the UN Human Rights Council, take an organization which currently serves to promote religious repression and both minimize the damage and push the organization in the direction of serving the purposes for which it was created, namely to promote religious and other freedoms. Thank you.
Certainly an incredibly concerning phenomenon that you shared there, but thank you for your analysis and recommendations, Professor. Stephen Perles is the founder of the Perles law firm, which specializes in private litigation against state and non-state sponsors of terrorism and financial institutions which help finance and launder money for terrorist organizations. In his 40-year career, Mr. Perles has successfully litigated against state sponsors of terrorism, including Iran, Syria, Sudan, and Libya, which have all resulted in reparations for thousands of American victims of terrorism and their families. Mr. Perles.
Two quick questions for everybody. Who was at the plenary this morning? I was on a panel. Okay, thank you. And lawyers in the room? You guys don't count. Lawyers out there? I'm sorry. Thank you. I could sum up a 10-minute lecture in one sentence. Buy Ord's book. It's a great book. At the risk of repeating what I said this morning, I don't work as a general rule in the religious freedom space. So what I'd like to do for 8 minutes, maybe 10 minutes, whatever. Okay, is talk a little bit about what we do in the material support of terrorist organization space, and then you folks can take some of that and build on it and see whether it is really applicable to your world. I think with not too much tweaking, it really is. But that becomes your decision, not mine. As we talked about at in the plenary this morning, the first case that became a major case in international reparations law that we engaged in was actually a religious freedom case. It was Perles versus the Federal Republic of Germany. It was the case that we discussed this morning that involved reparations for both U.S. Civilians and military personnel that wound up in, for one reason or another, wound up in Nazi concentration camps during the Second World War. That case was brought, the project was really started in 1986. We commenced litigation in 1991, and the case, how long did that case run? About 9 years, I think, all in. Long, a very long and difficult proceeding. There were some truisms in that case that carried through to the rest of the work, and that starts with the Department of State is not your friend. Okay, and they were very sorry. I mean, that's just the way it is. The Department of State is not your friend when you engage in this, because when you engage in these sort of activities, whether you're doing it for terror victims, or I suspect whether you're doing it for religious freedom reasons, they view it as disruptive to their core business, which is the maintenance of good relations, and they wish you would kind of go away and let their good relations carry on. In my case, at the expense of U.S. citizen victims of the foreign government that we've brought litigation against. Perles was an interesting case because all litigation under the foreign sovereign, all litigation against foreign sovereigns has to be brought under a single statute. And that statute is called the Foreign Sovereign Immunities Act. It is the end-all and be-all, again, involving litigation against foreign sovereigns, and that would include religious freedom cases as well as terror victim cases. In the Perles case, we tried to proceed under an exception to the grant of sovereign immunity called implied waiver. And in the 1980s, people like me were arguing an implied waiver doctrine against foreign sovereigns. And the implied waiver doctrine works something like this, and it was far more eloquently espoused by a D.C. Circuit appellate judge named Patricia Wald, who I think went on to serve in the ICJ for a while before her retirement. But the notion of implied waiver is, at some point, a foreign sovereign's conduct vis-a-vis an individual United States citizen becomes so noxious that the foreign sovereign has no expectation of immunity. And in the context of the Perles case, if not the slaving of a U.S. national in Auschwitz, then when? Well, we didn't win that argument. The D.C. Circuit declined to apply implied waiver against the German government. The case went up to the Supreme Court. The Supreme Court denied cert. It went back down. I filed an amended complaint. And then something which I think is very instructive to the world of religious freedom happened. We looked at who Germany had effectively rented out Mr. Perles to. Who were the German industrial concerns that the German government leased him out on a day rate for? And it turned out that it was Daimler-Benz, Hirsch, and Bayer, who happened to be the three largest companies in Germany, and collectively they had a multi-billion-dollar position in the US marketplace. So we then filed an amended complaint, and we named these three companies, and then we named Germany as the Federal Republic of Germany as a non-party. These three companies responded to the litigation by asking for a status call. So we're now, and they wanted to do it in chambers. So we are in chambers with a U.S. District Court judge in the District of Columbia named Stanley Sporkin. And by the time this amended complaint was filed, this had become a huge case, not only in international law, but it was followed far more openly on the press in Germany than it was in the United States, and it was still a very, very big case in the United States. And these three companies realized that this case seriously put their market share in the United States in jeopardy. It was just that powerful a proceeding. I mean, to give you an idea, Bill Clinton was then president of the United States. He effectively had already become an ex officio member of the litigation team. He had tried to settle his case. The Germans had rebuffed him. And I don't know if any of you know Bill Clinton, but he does not take no for an answer gracefully. He decided he was going to stomp on Helmut Kohl. So did Bob Dole, who was then the Senate Majority Leader who had fought in the Second World War, and so did Newt Gingrich and a lot of other members of Congress. So these three companies were facing this enormous political pressure. And the lead counsel for Daimler-Benz, which that's Mercedes, came, and he brought his German counterpart with him, and we're in chambers. And they asked Judge Sporkin if we could simply adjourn proceedings for 90 days because they were going to be resolved. The case would be resolved within 90 days. They were not willing to risk their market share. And I asked the lawyers from Mercedes quite candidly, given how hard the pushback had been from Chancellor Kohl in Germany, what assurances did we have that these three industrial concerns would be able to bring the German government around? To which he responded, "You don't understand how the German parliamentary system works. The Chancellor of Germany does not serve for a fixed period of time. He serves until he can no longer maintain a parliamentary majority." And I responded, And he said, "Oh, we're meeting with the Chancellor next week, and we'll be settling your claim." And I said, "And how do you know that?" And he said, "Because if he doesn't, he will no longer be Chancellor of Germany." Okay. Right. But that's the lesson for religious freedom cases. You really have to raise the profile of the cases. These cases are, and I think Ord spoke of this correctly in the context of the organizations he was talking about. These cases become the intersection of law and politics. That case could not have been won but for the effort we put out in the courthouse. It also could not have been won but for the bipartisan effort. And there are no political people on the face of the American landscape at that time that were as diverse as Bill Clinton and Newt Gingrich. Okay, right? But that's what it takes. The American governmental system is a system of checks and balances. You have independent, you have these independent organs or branches of government, and they all played a role in the resolution of the Prince case. It was a very effective intersection of the roles of the three branches of government. Now, Judge Wald asked this question in her dissenting opinion in the DC Circuit about implied waiver. At some point, a foreign sovereign's conduct vis-a-vis a U.S. national becomes so noxious that it has no expectation of immunity, and if not when someone is slaved in Auschwitz, then when. Congress, in the second case that we brought, which is Flato versus the Islamic Republic of Iran, that's the first application, or the first successful application of this body of law involving cases in the modern era. Congress answered that question, at least in the context of contemporary international outlaw conduct, which is really the world of terrorism, with something called the terrorism exception to the Foreign Sovereign Immunities Act. Now, if you are suing a foreign sovereign, you must, without exception, you must proceed under the Foreign Sovereign Immunities Act. The Foreign Sovereign Immunities Act is effectively the jurisdictional statute for all litigation against foreign sovereigns. It grants foreign sovereigns immunity from litigation in the United States, subject to a series of 7 fact pattern-based exceptions. For those, and what you do in any litigation against foreign sovereigns is you must frame your complaint so that it falls within one or more of these 7 exceptions. If you do that, you win. And if you don't, I'm talking about on a jurisdictional basis, you win the jurisdictional threshold. And if you don't, you lose the jurisdictional threshold. That sounds easy. In practice, it's frankly very complicated, and the law, a lot of the case law is inherently contradictory. But that's how you get this. That's how you get this done. So just to follow the bouncing ball very quickly. Oh yeah. Can I have 2 more minutes?
Absolutely.
Okay, thank you. Okay. You start out with Prins. Prins asked the question in implied waiver. When Flato starts, the first thing we do is we get this statutory change. So we get the answer to Judge Wald's question. You have an ask and an answer, and the answer is codified as a public law of the United States. It's an amendment to the Foreign Sovereign Immunities Act. We then move into Flato, which is the first case. We get a judgment against the Islamic Republic of Iran, and we actually ran a series of 4 cases, in 3 cases, 4 families in tandem with each other at the beginning. Flato, another bus bombing case in Israel, Eisenfeld and Duker, and what one could argue is a religious freedom case involving an American Catholic priest from Chicago named Father Lawrence Martinchenko, who was you're nodding. Did you know Father Chenko?
Yes.
I never met him, but he has a wonderful family. Father Jenko had been kidnapped in Beirut, and I think that the short form on the Jenko case is that the Iranians really genuinely believed that Catholic relief services in Lebanon was impinging on their ability to be able to recruit terrorists, and they tried to close Catholic relief services down. Father Jenko said no, so they kidnapped him. I mean, I don't think it was any more complicated than that. So we won cases for these 4 families, and we were able to get these 4 families paid. That is, we took real money away from the Iranians. And then it was like the floodgates opened, because we move into cases like Peterson, where we took around $1.9 billion away from the Iranians. We move into cases, again, using the same basic legal format. We move into cases like Gates versus the Syrian Arab Republic. Gates was beheaded by the predecessor to ISIS, was called AQI, at the behest of the Syrian government, who didn't like U.S. forces up on the Iraq-Syrian border. And now that this form of litigation has, frankly, the underlying litigation, the judgments on liability, have been quite well regularized now. The difficult part now, where big boys rules apply, the really serious litigation now is all in the judgment enforcement side. But I hope that helps all of you understand the basic framework. On the U.S. legal framework, currently, the plaintiffs that are entitled to proceed are United States nationals and non-U.S. nationals who are killed or injured in terrorist attacks as a result of their service to the United States. So we're talking mostly about U.S. Embassy employees. We represent about 150 Kenyan and Tanzanian families who either lost loved ones or had loved ones who were injured in the two big bombs that were effectively destroyed each of those embassy compounds. The response by different states, different terrorist states, to the underlying litigation is very different. The Iranians fight to the end, which is why it's been very expensive for them. Muammar Gaddafi was, in my view, the smartest player of all. He litigated very hard until he had to report for discovery, and then he wrote checks. I loved Tripoli under Gaddafi. It was really safe because, I was there under his invitation, and absolutely nothing was going to happen to me. I joked with my kids before I left that if I stepped off the curb looking the wrong way, some minder would reach out and pull me back onto the sidewalk. There's no way anything was going to happen to me there. The Sudan sort of took a middling approach to this thing. The Syrians fought, lost their assets in the United States. I still have lots of discussions with the Syrians. I think one of the more interesting facets of the practice, and then I'll turn it back to you, is I got to meet a lot of people in the Libyan government. I got to meet a lot of people in the Assad family. It's interesting to be able to talk to them. I came away from the process more respectful of the notion of constructive engagement. It's been an interesting 40 years for me. Thank you.
Fascinating material there. And, the lawyers in the crowd, I'm sure, have plenty of questions with regard to federal rules of civil procedure when considering FSIA exceptions. I know I certainly do. So thank you for that conversation. And I'd also like to remind the audience that we will have, hopefully, some time for some questions at the end, so definitely keep those in mind. Next, we have Eric Lorber, who is a principal in the cyber risk and regulatory practice at PricewaterhouseCoopers. There he advises on issues related to sanctions, anti-money laundering, and combating the financing of terrorism. Mr. Lorber's commentary on sanctions have been featured in the Washington Post, the Wall Street Journal, New York Times, and Foreign Affairs. He also has provided expert testimony before the United States Congress. Mr. Lorber.
Thanks, Rich, and thanks, everybody. It's great to be here with you all. I'm honored to be on this panel, in part because Rich, literally wrote the book on Lawfare, and Steve is probably the world's most successful and best-known litigant for the cases that he described in the type of litigation. You may be wondering why there's a sanctions guy on this panel focused on Lawfare, but there is a good reason for it. I'm also, thank you for the kind introduction, I'm also former U.S. Treasury, and when I was at Treasury, I was a senior advisor to the Undersecretary and worked on sanctions-related matters there. And in fact, one of the biggest areas I worked on was the Global Magnitsky Program. So the program was actually implemented, I won't say under my watch because that's not accurate, but I was there and participated in the implementation of the program in December of 2017. And the reason I think sanctions are an important part of this conversation is, at least when it comes to human rights abuses, they can serve two different objectives for human rights abuses, for religious abuse, and for other things that we think of when we think of malign activity by adversaries. On the first point, really, sanctions allow us to clearly signal and punish activity that we think is abhorrent and that deserves to be subject to, to restriction. So a little bit of background, in the U.S. government, we obviously have the Global Magnitsky Program. I was looking at the sanctions list right before we started today, and I think U.S. government has sanctioned 415 both natural and legal persons under that program since December of 2017, and they include some very, very bad people. They include, Pakistani organ doctor who trafficked in organs. They include, commanders of military units in Myanmar and Burma for engaging in genocide. They include individuals in China who have been accused of being responsible for, for activity in Xinjiang, really across the board. And one of the most important components of that program, of the GLOMAG, called the GLOMAG program, I know many of you have heard this before, is there's a nomination process. So you can actually, written into the law, into the Global Magnitsky statute, you can actually nominate, that may be a bad way to frame it, but you can identify individuals or entities that you think should be added to the sanctions list because they have engaged in serious human rights abuse or corruption of certain types. And so I'll tell you, one of the things that I received many, many times and reviewed many, many times when I was at Treasury were packets of information from NGOs saying, hey, have you taken a look at this person or this entity that's operating in this various jurisdiction? We think they're engaged in really, really bad activity. Here's the evidence that we have. Can you take a look? And we would always look into it. And many times, the designations that we came out with were directly related to and as a result of those packets of information that were provided to us. So if you're looking for kind of a quick way, not a quick way, but an effective way to actually impose pain on some of these people who have engaged in this activity, the GLOMAG program, direct reach out to Treasury is a way to do it. You can also, through the program, reach out to congressional representatives here in the US, so senators and members of the House of Representatives. They can also nominate, again, odd terminology, individuals to be added. The second major point I think that I'll make related to the importance of sanctions, the first point really is about punishing activity that, punishing activity for people who have victimized innocents. And to a certain extent, that is incredibly important. Like I said, it serves as a deterrent. It serves in a signaling function. It oftentimes hurts those targets that you sanction, can take away their access to the financial system. But oftentimes, and Steve will, I'm sure, corroborate this, that only gets you some of the way there, because the other really important objective is to making sure that victims of these individuals are made whole to the extent that they can be, right? There are always limits on that. And the sanctions architecture that has been established both in the United States, but also throughout the world, actually helps victims become whole for certain activities as well. And I'll give you a couple examples. One is in January of 2021, there was a sanctions evasion case that was, or an activity that was rolled up. It was 3 Iranian individuals who were engaging in sanctions evasion in South Korea, actually. They were moving Iranian funds, or funds that were in South Korean banks in violation of US sanctions, out of South Korean financial institutions into the world financial system. I think the number was over $1 billion worth. Huge number. And in 2021,
I'm suing them.
I was going to ask if you were involved in litigation. But as a direct result of the indictment and the sanctions evasion activity, DOJ, the Department of Justice here in the U.S., conducted a civil forfeiture action and seized $7 million that it is going to, I don't know if it has provided or will provide to certain victims of terrorism, clearly stated in the Department of Justice announcement. The second big, and I know Steve has been involved in this as well, the second big area where you're seeing sanctions play a role in compensation for terrorism in particular, but more generally for victimization, is in the context of the many fines that have been imposed against financial institutions for sanctions violations. So the biggest fine in the history of Treasury in terms of sanctions violations, BNP Paribas, many of you are probably very familiar, $8.9 billion, 2014. A significant portion of that fine was actually earmarked for providing to victims of terrorism. So there's a real effort to use the proceeds of sanctions violations that have occurred as a way to try to make individuals whole for the wrongs that have been done against them. So I don't want to go on too long. I know Sean has some great comments as well, so I want to turn it over to him in a second. But just think about sanctions in the context of A, it can be a tool and a mechanism to target those who've engaged in serious human rights abuses, and B, also a little bit more indirectly, it can also be used as a mechanism to at least try to make those victims of such activity, and terrorism in particular, whole again. So with that, I'll stop.
Thank you very much. Unfortunately, we appreciate your brevity, but unfortunately, you did have to be brief because the global Magnitsky mechanism is incredibly effective and very interesting to learn more about. Sean Nelson is a legal counsel for global religious freedom with ADF International, where he advocates on behalf of Christians and other religious minorities being persecuted for their faith around the world. In his role, he also engages with the United States State Department, U.S. Congress, and the United States Commission on International Religious Freedom, USCIRF, to coordinate efforts to promote international religious freedom worldwide. Sean.
Great, thank you, Rich. So I guess I'm the only one up here whose day job is actually in religious freedom, very specifically, in fact. So I'm with ADF International. We're a faith-based legal organization, work to protect fundamental freedoms worldwide. And as you might expect, pretty much all of these different areas, I have the UN, different kinds of litigation, and then the sanctions work are something that we engage in at different stages. We have offices in Vienna, Strasbourg, Geneva, New York, wherever, a lot of places, and then here in DC. So one of the things I think that I'll just do here is kind of respond from an IRF perspective about some of the challenges and some of the opportunities using each of these different mechanisms, because these are things I think about almost every single day, each of these different topics. I also mentioned that I'm co-chairs of the UN Working Group and the Justice and Accountability Working Group, the International Religious Freedom Roundtable. So we meet about every couple months. These are really things that are very core to what I do regularly. So I'll just start actually in reverse order with sanctions and with targeted sanctions. Targeted sanctions like through the Global Magnitsky Act or through different acts that have a lower standard, a lower burden, like different visa bans, have been something that the international religious freedom groups have been looking at ever since 2016 when GLOMAG was passed. Really appreciate IDC's support on some recent stuff when we were looking at doing the permanent reauthorizations for GLOMAG just a few months ago, once after the Ukraine war really became a big thing because of the Russia targeting. And so a lot of us really support that act. It's been used for, Andrew Brunson was actually a very great example of it being used in terms of lawfare to get him back. It was sort of imposed on the Turkish officials. In that case, if you don't know Andrew Brunson, he's a pastor, American pastor, working in Turkey for decades. Just a wonderful man. He's around here, and he was accused of various national security, terrorist kinds of things, and detained. And so in one of the earliest and kind of most high-profile uses of Global Magnitsky, and Executive Order 13818, then President Trump put those sanctions on a number of Turkish officials, and it very quickly got him released because that's not worth it, right? That raises the cost of things very high, and that's the whole point. We've seen that. We've seen Chen Quanguo, the sort of one of the masterminds of the Uyghur genocide, the camps in Xinjiang. There have been some of these against Iranian militias who were involved in different atrocities for Yazidis, for Christians, and different groups up there. So it's a really important tool to the religious freedom world. When we were doing that, there were some concerns about freedom of speech and freedom of religion, how when you allow these sanctions programs, there is a lot of discretion that you're giving to executive agencies. So how do you cabin that and balance those things? But we're really happy with the result there. Things on the sanctions that I think are things for the future. We're definitely looking at creating more of these submission packets. One of the hardest parts of doing a submission packet, there's a number of difficult parts, and it comes into all of the different aspects of the work, is getting very good identification information about the actual particular violator, right? That's extremely challenging, especially when you don't have a U.S. nexus, when you don't have somebody who's right here. These are very, very difficult countries. They're dangerous countries. They're hard countries to move information in and out of. A lot of times when you're moving that information, that puts people at risk. And so just getting the information and finding out who is the violator can be a difficult thing. So that's important. Getting independent sources, again, these are journalism is in a lot of these places is not great either, right? You have witnesses, you have all sorts of language barriers. And in fact, you may even just have name challenges, like in China or in the Middle East, you have a lot of people named Mohammed, so you have to do a much better job at identifying who the person even is. And then last, this was sort of mentioned, to get these kinds of sanctions, especially the high-profile ones, you need to provide the U.S. A good hook for why they have an interest in sanctioning this person, because you're disrupting financial flows, you're causing diplomatic issues potentially. So you really need to give them a very good hook. And a lot of times for the countries that we're dealing with, there isn't an immediately obvious good hook, right? The country may be small, or there may be other strategic interests going on. You think of China, right? China is seen as a big enemy. There are a lot of other countries that are very bad religious freedom violators who we see as a strategic partner against China. So that makes it very difficult. So a lot of what we try to do is try to create the interest around the hook, right? That actually happened a lot with China and with the Uyghur genocide. A lot of the IRF groups have done that. I'll just be very, very brief with the other things because I know we're at 3:30. On the UN, with the Human Rights Council, I think, all of the different avenues to do that. We work a lot, with the UPR, but that's a very broken process. We're exploring a lot of different things with how do we really combine all the NGO work, all the information that we're doing to kind of ping different embassies or ping different missions, ping different countries, and really figure out the best constellation of things to put the most pressure on violators. And then for the litigation, this is something where a lot of us really do want to do things. One of the hard parts is the U.S. nexus with it, with identifying things. And another thing, which is that there are a lot of really harmful policies that themselves don't rise to a mass atrocity like a terrorist kind of thing or something like that, but that over widespread areas, can just totally decimate a religious population or religious community or make it extremely hard. And in fact, those governments know those things, and so they set up these legal and policy regimes to avoid precisely those things, right? They try to avoid all the traps. And so that's the fun of doing this, is trying to figure out when you're playing against usually a pretty intelligent opponent who knows what you're doing, how do you beat those traps? And so really appreciate the time for Rich to allow us and for everybody up here.
Thank you, Sean. We appreciate that. The great part about these opportunities is that there's so much great information to share. The downside is the fact that there's so much great information to share and not enough time. So thank you all. The questions that you have, I'm sure they're great, and I'm sure you can accost them outside in the hallway, and they'll be happy to talk to you. But thanks for your attendance and your support, and we wish you a great afternoon. Thank you.